Imagine your smart speaker, your smart doorbell, even your smart fridge suddenly testifying against you in court. Sounds like science fiction, right? But as our homes get smarter, the legal implications of their data are becoming terrifyingly real. What happens when your smart home designed to serve you legally betrays you? You are curled on your sofa having a private, passionate argument with your partner. Your Alexa in its corner glows a soft blue, listening as always for its wake word. Months later, in the throes of a bitter divorce, your spouse lawyer submits a transcript of that very argument, sourced not from a hidden recorder but from the benign-looking smart speaker you bought to play music and set timers. Across town, a man is suspected of arson. The police arrive with a warrant not for his computer but for his smart meter energy consumption data. The logs show a drastic anomalous spike in electricity usage at 2:17 a.m. on the night of the fire, precisely coinciding with the ignition of an accelerant-fueled blaze. His own home utility monitor has become the star witness for the prosecution. This is not a speculative episode of Black Mirror. This is the emerging legal frontier of the 21st century. Our homes, once sacred castles of privacy, are morphing into densely networked ecosystems of sensors, microphones, and cameras, constant silent witnesses to our most mundane and intimate moments. We invited them in for convenience, security, and efficiency. We did not anticipate they might one day take the stand. The legal betrayal of the smart home is a multifaceted crisis. It pits our fundamental right to privacy against the state power to seek evidence. It challenges centuries-old legal doctrines like the Fourth Amendment and the spousal privilege. It forces us to ask, in a home that hears, sees, and records, where does the testimony of a thing end and a violation of the self begin? This article delves into the chilling reality of smart home data in the legal system, exploring landmark cases, dissecting the technology, and confronting the profound philosophical and legal questions we can no longer afford to ignore. Part 1: The digital crime scene. Your home as a witness. The modern crime scene is no longer just a physical space cordoned off with yellow tape. It is a digital realm, a data footprint scattered across servers from Silicon Valley to Shenzhen. In a smart home, almost every interaction leaves a trace. The always-on witnesses. Smart speakers like Amazon Echo and Google Nest are not merely waiting for their wake words. They are in a constant state of auditory surveillance, listening for that wake word in a continuous buffer of audio. While companies claim only post-wake word audio is sent to the cloud, the local buffer can be rich with ambient conversation. In 2019, it was revealed that teams of human contractors routinely listen to and transcribe snippets of these recordings for product improvement. The legal implications are staggering. A device can capture a confession, a threat, or evidence of intent without the user explicit command. Smart doorbells and security cameras from companies like Ring and Nest do not just protect your perimeter, they create a perpetual documentary of your comings and goings, your visitors, and your activities in your own yard or hallway. Footage can place a suspect at home or not at a critical time, show them in a particular state such as intoxicated or injured, or even capture audio of domestic disputes through open windows. Law enforcement agencies now actively seek this footage via warrantless data sharing partnerships with companies like Ring, creating a de facto private surveillance network. Smart health devices like sleep trackers and smart scales do more than measure steps. They monitor heart rate, sleep stages, and location. In a 2015 murder case in Pennsylvania, Fitbit data from a victim device was used to contradict her husband's account of the night she died, showing she was awake and walking around when he claimed she was asleep. Her own wearable testified to her final moments. Smart appliances and the Internet of Things turn the innocuous into informants. A smart refrigerator internal camera could show what food or beverages were present. A smart thermostat like Nest can testify to someone presence or attempts to simulate it. A smart meter can timestamp extraordinary energy use. Even a connected washing machine could, in theory, provide data on cycles run, suggesting cleanup activities. The data trail from your hallway to the courtroom. How does a snippet of audio from your kitchen end up as Exhibit A? The journey is complex. The process begins with a trigger and capture. An event such as a sound, motion, or command triggers the device to capture and encrypt a data packet. This packet is then transmitted via your Wi-Fi to the manufacturer cloud servers like Amazon Web Services or Google Cloud. The data is stored on these servers, often indefinitely, and may be analyzed by algorithms or human reviewers. When a legal demand is made, prosecutors or civil litigants serve a warrant, subpoena, or court order on the tech company, compelling them to preserve and hand over specific data. Finally, in court, a custodian of records from the company must authenticate the data, attesting that it came from the defended device at a specific time and has not been tampered with. The defense can challenge its reliability, but the hurdle for admission is often low. The legal system built for tangible evidence is struggling to adapt to this stream of digital testimony. The data is considered a business record of the tech company, giving it an aura of sterile objectivity. But is it? These devices are not flawless court reporters. They can mishear, glitch, be manipulated, or be activated by mistake, yet their output carries a powerful persuasive weight. The impartial silicon witness. Part 2: The legal battleground, precedent, privacy, and the Fourth Amendment. When your smart home betrays you, it does so within a legal framework that is being violently stretched. The central conflict revolves around the Fourth Amendment of the U.S. Constitution, which protects citizens from unreasonable searches and seizures and guarantees the right to be secure in their persons, houses, papers, and effects. The third-party doctrine you have already confessed. The most potent legal tool against smart home privacy is the third-party doctrine established in the 1970s in Smith v. Maryland. This precedent holds that information you voluntarily surrender to a third party like a bank or a phone company is no longer protected by a reasonable expectation of privacy. You assumed the risk. Tech companies have successfully argued that by using their services you voluntarily give them your data, that ambient audio clip is stored on Amazon server, that doorbell footage is on Ring Cloud, that heart rate data is on Fitbit database. By this logic, you have no Fourth Amendment protection against the government obtaining that data with a simple subpoena, which is a lower standard than a warrant. You chose to buy the device and accept the terms of service, a contract few read, thereby consenting to this data harvest. The betrayal is thus baked into the deal. The mosaic theory and the digital whole. Critics, including Supreme Court Justice Sonia Sotomayor, have warned that the third-party doctrine is ill-suited to the digital age. A new concept, the mosaic theory, is gaining traction. It argues that while a single data point like one location ping might not be private, the aggregate collection of thousands of data points over time creates an intimate, comprehensive picture of a person's life, a digital mosaic that should be protected. Your smart home is the ultimate mosaic builder. A single day data might reveal when you woke via your sleep tracker, what you ate via your smart fridge suggestion, your morning argument via your smart speaker buffer, your work from home schedule via thermostat patterns, your entertainment choices via your smart TV, your evening visitors via your doorbell cam, and when you finally slept. This totality is arguably more invasive than the general warrant the founders sought to prohibit. Courts are beginning to recognize this, but the law lags far behind the technology. Landmark cases when the home spoke. In the Arkansas murder case State v. Bates in 2016, prosecutors sought audio recordings from an Amazon Echo in a home where a man was found dead in a hot tub. They believed the device, which was playing music at the time, may have captured evidence of the crime. Amazon fiercely fought the warrant, arguing for First Amendment protections for user speech. The case was ultimately resolved when the defendant consented to release the data, but it set a crucial precedent for the legal battles to come. The Fitbit witness case from 2015 opened the floodgates. It established that data from personal wearables is not privileged health information in a criminal context, but is a discoverable business record. In domestic disputes and smart recordings, family courts are increasingly fielding requests for smart home data. Spouses subpoena Alexa logs to prove verbal abuse or infidelity. Doorbell camera footage is used in custody battles to document apparent behavior. The home testimony is becoming a routine weapon in the most personal of conflicts. The battleground is shifting. Some states are passing laws requiring warrants for electronic data. The Supreme Court in Carpenter v. United States in 2018 ruled that accessing months of cell site location data does require a warrant, carving a significant exception to the third-party doctrine for detailed digital records. This ruling is a beacon for those arguing that the intimate, constant surveillance of a smart home deserves the highest constitutional protection. Part 3: The Philosophical Abyss, Consent, Agency, and the Testimony of Things. Beyond the legal statutes lies a deeper, more disquieting question. What does it mean when our possessions testify against us? This strikes at the heart of personhood, consent, and the nature of testimony itself. The illusion of informed consent. We consent to data collection through labyrinthine end-user license agreements. This is a legal fiction. No reasonable person can be said to genuinely understand or anticipate the scope of surveillance they are inviting. Did you buy a smart TV to have its microphone potentially capture your private conversations for ad targeting, or worse, a criminal investigation? The consent is coerced by the desire for modern functionality, creating a pervasive low-grade betrayal as a condition of participation in society. Objects as witnesses, a legal paradox. English common law has long held that objects cannot testify, they are evidence but not witnesses. A bloody knife is mute, its story is told by forensics and human context, but a smart device is different. It does not just bear physical marks, it generates a narrative. It creates a record of events from its own perspective. This blurs the line between passive evidence and active testimony. Are we granting agency to machines, and if so, who is responsible for the truth of their testimony? The user, the programmer, the algorithm? The erosion of the sanctum. The home has always been more than a physical space. It is a psychological and legal sanctuary. It is where we are most ourselves, most vulnerable, most unguarded. The smart home, with its panopticon of sensors, systematically demolishes this sanctuary. It creates a state of perpetual performativity where one must always consider the invisible audience of servers and algorithms. This chills free speech, stifles intimate relationships, and creates a pervasive anxiety, a low hum of legal vulnerability in the one place we are supposed to feel safe. The diary versus the witness problem. In Fisher v. United States, the Supreme Court recognized a privilege for compelled production of personal diaries, seeing them as an extension of one's inner thoughts. Could the data from a smart home be seen similarly? The aggregate data is a digital diary of your daily life written not by you but by your environment. Should it be protected as an intimate compendium of your existence, or is it merely a record of observable facts free for the taking? The law has yet to grapple with this dichotomy. Part 4: The Future: Forensics, AI, Deepfakes, and the Weaponized Home. The trajectory points toward an even more complex and terrifying future. We are moving from the home as a witness to the home as an active participant in legal narratives. Predictive policing and pre-crime algorithms. Smart home data could feed into predictive policing models. An algorithm might flag a home as high risk based on patterns, raised voices detected by smart speakers indicating domestic dispute risk, changes in sleep, or biometric data suggesting stress or substance use or unusual comings and goings. This could justify preemptive welfare checks or even surveillance, penalizing people for patterns algorithms deem suspicious. AI-generated testimony and deepfake environments. As AI improves, the raw data from smart homes, such as audio snippets and motion sensor triggers, could be used by prosecutors to reconstruct or simulate events. A prosecutor might say, "Your Honor, based on the acoustic profile and the smart lock data, our AI model shows the defendant was standing here when he said this." The defense would face the nightmare of cross-examining an algorithm. Conversely, what if a sophisticated hacker or a malicious actor injects fake data into your home ecosystem? Could you be framed by your own smart fridge? Proving the authenticity of digital evidence will become a field of war. The insurance paradox. You install smart sensors for an insurance discount, such as water leak detectors or connected fire alarms, but what happens when that data is used to deny a claim? Your smart bed shows you were not asleep at the time of the alleged burglary. Your smart oven data contradicts your burn damage claim. The very tools for safety become tools for corporate avoidance of liability. Global implications and authoritarian control. In liberal democracies, this is a legal struggle. In authoritarian states, the smart home is a ready-made tool for social control and persecution. Dissidents' homes can be fully monitored. In China, the social credit system is already integrating data from various sources. The smart home would be a perfect feeder. The technology is neutral, its application is not. Conclusion: reclaiming the castle, a path forward. The betrayal is not inevitable, but averting it requires deliberate, urgent action. We stand at a crossroads. We can accept a future where our homes are porous to legal intrusion, or we can build a new legal and technological architecture for the digital age. Legislative action. We need a digital Fourth Amendment. Legislation must clearly define smart home data as deserving of the highest privacy protection, requiring a warrant based on probable cause for its access regardless of the third-party doctrine. Laws must mandate data minimization, limiting what is collected and stored. Right to delete laws must allow users to truly erase their data from company servers. Technological solutions. On-device processing is crucial. The future must shift from cloud-dependent models to edge computing. Let your smart speaker process commands locally. Let your doorbell camera store footage on a local encrypted hub. Data never leaves your home unless you choose to send it. Strong default encryption should be the standard, not the premium option, making data unreadable even to the manufacturer. Open source and auditable hardware are needed. We need devices whose code and data flows can be audited by the public, not hidden behind corporate secrecy. Personal vigilance. As consumers, we must make informed choices. We can opt for dumb appliances, use physical shutter covers for cameras, regularly delete voice histories, and segment our home networks using firewalls. We must read privacy policies and demand better. Our purchasing power is a vote for the kind of future we want. Judicial evolution. Courts must embrace the mosaic theory and recognize that the totality of smart home data paints a picture so intimate that its seizure is a search of the person, not just their property. They must raise the bar for authenticating digital evidence and allow robust defense challenges to the reliability of algorithms. The dream of the smart home was one of seamless comfort and empowered living. The legal nightmare is one of silent witnesses and perpetual vulnerability. The question, what happens if your smart home betrays you, is being answered in courtrooms every day. The testimony is mounting. It is now our responsibility as citizens, consumers, and humans who still value a private refuge to write the next ruling. We must ensure that our smart homes remain our servants, not our wardens, and that our castles, though digital, can still have walls that the law respects. The alternative is a home that is no longer a haven but the most efficient informant you will ever own.